to carry on with some scenarios that I put to professionals that work within the criminal justice system after the Victims Summit, I was wanting to hear the realities of the situation from their perspective, as opposed to what I hear all of the time from the victims of crime perspective. Because I wanted to understand where it was all falling apart, or where the misunderstandings were, and what we could do to make sure that everybody was working towards the same objective and outcome of putting the victim's needs on a parity to the defendant's needs. Because it's often felt from victim and survivor's perspective that the defendant's needs are always put above their needs. And it's not about taking away the needs of defendants, but making sure that victim and survivors' needs are put on the same level of defendants' needs. So it's often said by victim and survivors in sexual abuse or sexual assault cases that their clothing, for example, is always discussed in a court of law. What they were wearing is often discussed. And this is thought as victim blaming from the point of view of the victim's perspective. Why should clothing, what was worn on the night or the day of the incident, why is that even relevant? Because it shouldn't be relevant. The fact that you're wearing, for example, a miniskirt and then you was raped, why is that even connected? Why is it even relevant? Yet it's often brought up in the case. But why is it relevant? So I said to the judge in this scenario, why would that even be brought up? And he said that it shouldn't and it isn't. So that's his reality, that it shouldn't and it isn't. But yet when you hear from victim and survivors in these cases, they always say, and organisations that help victim and survivors get through these cases, they always say, but it's brought up to discredit the victim. So again, why is there disparity in this? Why is there this difference? Another thing that was brought up in the Victims Summit was that victims and families of victims within the court, when they express emotion, they are told that they are not allowed to express that emotion because it's very off-putting for the jury. So if you are going to react or respond in an emotional way, that you need to leave the court. Now, victims and families of victims who express emotion have said, why are they not allowed to express that emotion? Surely it's okay to do that and it's a natural thing to do that. When I spoke to the judge about this, he said that, of course, emotions and that should be able to be expressed, but when you are a judge ruling over a case and you've got jury members trying to listen to the facts, to the evidence of the case, any kind of disturbance, i.e. emotion or anger outbursts, is very disruptive to the members of the jury. And that is why emotional outbursts or anger outbursts are really not appreciated in a court of law because of that fact. Now, I've never seen it or heard of it from that perspective before. So do we need to have an understanding, to have a conversation about all of these things, so we get to understand that it's not the judge being an obnoxious person and not wanting to have these outbursts in their courts, but they have this duty of care to the jury to keep them focused in just the facts and the evidence of what is being put before them, without the angry outburst, for example, that might trigger the actual jury. So I've never seen it from that perspective before, and I don't know whether I agree with it, but I'm just trying to get the conversation happening around different perspectives, really. That's what I'm trying to bring to the fore. What else was said that I was really interested to bring to your attention? So it was clothing, it was outbursts, that the complainant, the victim, is not allowed in the court of law to watch the rest of the proceedings after they've given their testimony. It's often recommended that victims of crime don't attend the rest of the court proceedings. They're often told that, don't attend. And often victims and survivors say to me that they do want to attend and they're told not to attend. And again, I put this to the judge, and he said, no, of course they're allowed to attend. Of course they are. It's their right to attend, but it's often said to them that maybe they might not want to hear what is being said, and then the outburst or the potential outburst from them from hearing particular hard testimony might not be in their best interest. So it's really interesting to hear from all kinds of perspectives, or both sides of the case, for example, to hear all of these different perspectives, so that we have an understanding and an awareness and education of why things are being said and how it's being received. So I just think that the Victims Summit is really important for everybody to learn from the different perspectives and why things are often put on the table, and the understanding and how it's being received. I just think there needs to be more of that, more understanding as to why things happen the way that they do, and also how can it be shared or put on the table in a different way, so that there's understanding on all sides, and where we can come to a place of best practice, so that the victim feels empowered and not disempowered, and also the professionals feel like that they're understood more, and the reasons why are understood more, and just to make sure that the pathway is in the interests of the victim, but also that, I think that we can understand it from the professional point of view more as well. I don't know if I've actually explained myself clearly, but I think that the conversation needs to be developed and needs to be on the table, so that we can understand both sides more. Again, would love to have your input on this and your comments. Thank you.